Especially, what's what is a disciplinary hearing for the ordinary man?
So what I would say is that a disciplinary hearing, it will be a formal meeting between the employer and the employee. So where the employer has a chance or the opportunity to lay out the allegations and the evidence in support of those allegations against the employee. So that's the breaches that the employer believes that the employee engaged in. And at that meeting as well, the employee has a chance to respond to those allegations and also present evidence if the employee has any. So it's really a structured way of dealing with disputes or allegations of breaches of contracts between the employer and employee.
Especially, what should an employer ensure for a lawful disciplinary hearing?
Okay, so for the employer, before you even begin to think of having a disciplinary hearing, you should ensure that you have a disciplinary code. So it can be part of the contract of employment, or you can decide to have a separate employee handbook in which these things will be written in. That's the rules of the organization or the company, and what will happen if the employee breaches those rules. Of course, not everything can be written down, but as much as possible, which or whatever the employer deems will be something that will tarnish their image or something that is not acceptable to that particular organization. It should be written down and it should be made known to the employee. So either at the time you've employed the person, or if in the course of the employment you come up with a disciplinary procedure, it should be provided to each of the employees so that they are aware that if I go against this rule, I'm going to get punished for it, and this is how it's going to go. So first of all, the employer has to ensure that the employees are aware that there's a handbook or it's part of their contract that if you go against these rules, you are going to be punished for it. So once these allegations come to light, if it's alleged that the employee has breached any rule in the disciplinary code, then the employer has to first investigate. There must be an investigation done. You can't just go straight and say, okay, we are going to have a hearing, so let's come on this day and let's talk about it. No, you first have to have an investigation. And during the investigation stage, that's where you get all the facts in respect of the allegations that have been put against the employee. Sometimes in the course of the investigation, you realize that new things come up, things that may not have come to light when you were first told about the breach of the rule by the employee. So during the investigation, you may find something else that the employee may have done and you were not aware of. So it's important that investigations are done, and the investigation should be based on the facts. It shouldn't be hearsay or because somebody in the organization may not like that particular employee. So whatever they say, you're going to take it. You must know that there must be facts, must be based on facts. So that's where you gather all your evidence. If there are any witnesses to the incidents that may have happened, you can let them write down their statements and just gather all these things. And once that is done, usually there's a report, an investigative report. So when the report is ready, maybe done by the HR or someone else that the employer may have gotten to take care of the investigations, the employer can go through the report and see if there's a case for a hearing to be done. So in that situation, that's something that the employer must take note of. So you must first make sure that an investigation is done. After the investigation, then you realize that okay, we need to have a hearing in order to let the employee have the opportunity to state his side of the story, his or her side of the story. So in that regard, the employer would invite the employee to a hearing, but the employer should make sure there's enough time for the employee to prepare. So you can't give the employee notice of the hearing today and then say on Monday we have a hearing. That doesn't give the employee enough time to gather evidence that the employee may have or even prepare. So it's important that enough days, usually it's about 5 days or a week, just to give the employee the chance to form his or her defense. So you must ensure that in that invitation to the disciplinary hearing, the employee must know the allegations against the employee and what rule the employee breached. It must be clear that you went against this and this rule, which is stated in the employee handbook or in your contract. It must be very, very evident. You must also allow the employee to bring a companion. It can either be a trade union representative or someone that the trade union would have elected to be present. You can also allow the employee to bring maybe a co-worker, or maybe if it is in your handbook, your employee handbook, that the employee can bring a lawyer. It's also possible. But in situations like this, where the employee is already tense, then feeling okay, I'm going to sit before like people and discuss these allegations, it's important that you allow the employee to bring a companion, to just a form of support, should I say. Um, yes, and you must also state clearly the sanctions that the employee may face at the end of the hearing. So you must be clear that for these allegations against you, if you are found guilty, you are either going to be dismissed, or you are going to be terminated, or you are going to be demoted. It must be stated very clearly because the employee must be made aware of these things. So that's something an employer must watch out for. And all this is stated in the notice. That's the invitation to the disciplinary hearing. So all that must be stated in there. So those are the things that the employer must watch out for when thinking of organizing a disciplinary hearing against an employee.
For purposes of illustration, Nestle has a worker, an employee, who consistently comes to work drunk. In the terms of contracts, employment contracts with such an employee who is made it a habit to come to report to work always drunk, Nestle does not capture drunkenness as an action for which disciplinary proceedings will be instituted against you. Neither does Nestle have a code of conduct that captures drunkenness as grounds for punishment. What is the recourse of Nestle?
So in this situation, Nestle can still punish the worker. It's possible because in the beginning I stated that it's not everything that may be captured in your code of conduct or employee handbook. In such a situation, the worker or the employer is entitled to punish such an employee. But in this situation, the employer will be guided by the Labor Act of Ghana. The Labor Act is the law that governs labor relations in Ghana. So if there's a situation that's not covered by your handbook, such as being drunk, in the Labor Act, Section 15, specifically Section 15 EIII, it states that the employer is entitled to terminate the employment of the worker if it is found out that there's a proven misconduct against the worker. So it must be proven. So in this situation, that's where the hearing may come in. Investigations may be done, and the hearing will come in. Or if it's affecting the work of the organization, Section 15 also covers it. The employer is entitled to terminate if it's proven that the worker is incompetent to work. So if your drunkenness is affecting your competence in the office, then I mean the employer has an opportunity to institute the hearing, then decides which sanction, whether it to be a demotion or it to be termination or outright dismissal. It will be up to the employer.
So I work with TV3, and my editor and manager call me to the office, and they tell me they're dismissing me. They give me stated grounds, or let's assume they don't, and they fire me without a hearing. Do I have a recourse?
Of course, you have a recourse, definitely. So we always advise that the employer should have a handbook, employee handbook, or a disciplinary procedure as part of the contract of the employee, which the employee should be made aware of. So if in such a situation an employee and you've just been dismissed on the spot, I think the first thing that you have to do is look at your disciplinary procedure. What does the company provide for in situations where they are accusing you or there are allegations against you in respect of the work that you are doing? You should look at the procedure that the organization provides for. Is that what the employer did? Did the employer go through all those stages? If there's nothing like that, or if you don't have a code of conduct, no employee handbook, or there's nothing to rely on, the employee can either decide to take it to the National Labor Commission, which will try and, let's say, mediate or try and solve the issue between the employer and their employee. Or sometimes employees just go directly to the courts to seek redress that I was unfairly dismissed or the employer breached my contract of employment, so I'm suing the employer. So these are some of the options that I would say the employee will have in such a situation where the employee wasn't given a hearing, the employee didn't know what he was being accused of, he was just dismissed for no reason apparently. These are the options that the employee may have a look at. So as a legal practitioner, what our firm or what I would advise is that all organizations or companies should have an employee handbook first of all, or as part of the terms of the contract of employment, it must be stated in there your disciplinary procedure, especially the rules that your company wishes the employees to abide by and the sanctions that will be meted out to the employees if they are found guilty of breaching those rules must be stated very clearly. Secondly, this should be made known to the employees. Make sure that the employee is aware of these rules. Again, you can't write everything down, but as much as possible, write down whatever it is your company does not desire an employee to engage in whilst working for you. Also, the in situations where the employer believes that the employee has committed some breaches of the rules, it's important that a hearing is done, or first an investigation is done into the allegations before a hearing is also done. No matter how minor or the gravity of the allegations, it's better, or should I say safe, to go through the investigative stage, then the disciplinary hearing. Then you can come to a conclusion on which sanction to apply to that employee. Because most of the times, what you see is that the employee will straight away go to the courts and say, this organization unfairly dismissed me. And it's a waste of time and money because you are now going to engage lawyers, you're going to get advice. I mean, it's good for the lawyers, but yes, on the company side, it's not a good brand because cases in court are public, should I say. So it's advisable that in situations, if there's any form of breach of your company's rules, just go ahead, give the employee the chance to state his or her side of the story, allow for room for the employee to bring witnesses or any form of evidence that the employee may have. It's also good that before the hearing is even done, the employee is given adequate notice. So in that notice, you must state the allegations clearly that this is the rule that you breached, and these are the sanctions that will be applied if you are found guilty. And you must also give the employee enough days between the time he receives the notice and the day of the hearing to prepare adequately. The last thing you want is for the employee to say you were not fair. In disciplinary hearings, the main or the key words are fair and transparent. So, as much as possible, organizations in everything that they do when trying to discipline an employee, think about it. It has to be fair, it has to be transparent to avoid the headache of either the employee appealing your decision or the employee going to court or even the National Labor Commission. So, just to be on the safe side, try as much as possible, have your handbook, make sure it's accessible, available to all employees, give them fair and transparent hearings. And I mean, even if it goes to court or the NLC, you're able to defend yourself. And these are the measures we took It was stated clearly there that these are the steps that have to be taken, and we did our part, and it was found that the employee breached this rule, and we had the right to either dismiss, terminate, demote. It was up to us, and we did that. So that should be okay. So if the employer does that, you are good.